Welcome to Inside Employment, a podcast series by Herbert Smith Freehills that explores the latest developments in Australian employment law and practice.
So hello and welcome to Inside Employment, a new podcast series from Herbert Smith Freehills that looks at employment law issues and developments for employers in Australia. And my name is Tony Wood. I'm a partner in the Employment, Industrial Relations and Safety team here at Herbert Smith Freehills, and it's my pleasure to welcome to the first episode of Inside Employment to my colleague Executive Counsel Lucy Boyd and Senior Associate Katie Ball. How are you, ladies?
I'm great, Tony. It's a pleasure to be here with you, and I look forward to co-hosting this series with you.
Thank you. Yes, and I welcome the plug for Inside Safety.
Well, I think we're going to get up to a bit of mischief on this series as we keep going. And don't make me laugh. But we're running off a really great introduction by my colleague Rowan Doyle, who's been running the Inside IR podcast. And Katie, you're right, also will be running the Inside Safety podcast, which I'm sure you'll be making other appearances on during the course of this year.
We'll see how we go after this one. I'm invited back.
And with Steve Bell. But the purpose of today's session really is to give a bit of an entree to our clients and viewers of this and listeners of this podcast about what we see as some of the major developments that are likely to occur, or the major issues at least that are likely to be affecting Australian employers during the course of 2025. And we had a pretty big year legislatively and in case law and other developments in 2024. So the top 5 list we're going to run through, and I'll give a tiny little bit of a spoiler here, Lucy, that the issue that's arisen probably in just the last week or so has been this phenomenal barrage that we're facing, a backlash actually against what's either called DEI, pejoratively somewhat, or diversity and inclusion in Australia. And somehow I think that's going to sneak its way onto the list. What do you think?
Absolutely, and it's an issue that has certainly captured my attention for the past couple of weeks, so I look forward to chatting about that later.
And do you want to get going on the top 5?
Yeah, sure. So it is. We've had a bit of back and forth about the list, but I think there's a consensus on what the key 5 issues will be on the plate for this year. With a federal election pending, we're not expecting the same levels of major legislative change that we've seen in the previous couple of years. But what we are expecting is that we'll continue to see the impact that those reforms will have, and there's a few interesting test cases running.
Just slow down. We're going to be dealing with that as one of the 5. That's not number 1.
It's not number 1, but the other, I guess, key takeaway is we're expecting it to continue to exist in this heightened regulatory environment. And in that vein, it wasn't hard for us to agree, Tony, that payroll compliance will again be the number 1 issue this year.
And before everyone tunes out, bored to tears by this subject, let's just say it's been on the top 5, if not the top 2 or 3, for really the past 4 or 5 years. And we've seen so much publicity in the media through employers either self-reporting or being prosecuted. And I'm not just talking about the local sushi shop or the cafe around the corner. We've seen a real exposure of a lot of very big and reputable businesses who have already either had to confront these issues with the Fair Work Ombudsman in the media or the courts. But at least we know what the likely results are going to be over the next couple of years, because we are involved confidentially with a lot of employers who are having to grapple with this issue. So frankly, underpayments, wage compliance, coupled with the introduction or the commencement, if you like, of the wage theft laws in Australia, and the incessant, that sounds a bit judgmental, the constant pressure imposed by the Fair Work Ombudsman on employers, and what their stated desire is to secure or pursue at least employers which are large corporates, employers in aged care, and what other areas are they focusing on?
Restaurants and disability support services. So they've mentioned that in their corporate plan. And another intention that they've made clear is their preference for prosecutions over enforceable undertakings.
Well, I don't like to hear that, because a lot of our clients, of course, are very well intentioned. In fact, it's worth making this point. I don't think that there are that many employers who have deliberately, certainly maliciously or even recklessly intended to underpay their employees. However, it is probably fair to say that a lot of them have not applied kind of the sufficient rigour that might be expected for a compliance issue maybe that was dealt with in other areas. And our clients in the HR departments and the legal departments who are managing these things are really playing catch up to ensure that their systems are compliant. And the complex issue of complying with awards, enterprise agreements, legislative instruments, and a combination of those is making life exceptionally difficult.
I think that's right. It's the complex system that we're existing in, but we may get some clarity over some key issues this year with the long-awaited Justice Perham's decision from the Coles and Woolworths prosecution.
I've heard that for a while. I mean, this decision was being heard, a year ago before the federal court, and there's a lot of pivotal issues actually arising in that litigation, but foremost amongst those is the capacity or ability of an employer to effectively set off or offset, if you'll use another term, overpayments against underpayments. And there are a number of decisions of various courts and tribunals which don't really arrive on a very clear landing on those issues. And unfortunately, Justice Perham is going to have to be the one who's going to have to make this decision, which is going to affect not only a lot of employers about the practices that they apply, but also will be highly determinative of the approach that the Fair Work Ombudsman is going to take in prosecutions. And we do know from experience and liaising with the flow that is a key issue for them that they are not, at least yet, until we get this decision from the federal court, prepared to concede. Yep. So I think that's going to be really fascinating.
That's right. I think a lot of employers have been waiting with bated breath for that decision. And I guess finally, Tony, can you talk to us about your favourite issue, long service leave?
I hate long service leave, but it is the most complex area of, in employment law, frankly. And I really have sympathy for our clients who are out there grappling with an array of, 6 at least separate state or territory pieces of legislation in relation to long service leave, potentially award-derived long service leave terms, and other sometimes incorporated within enterprise agreements. And when you have got different rates of accrual, payments and the like, it becomes highly complicated. And frankly, if you read some of the, mostly, however, let's say these are regulated by state jurisdictions, if you read the regulators' own web pages, you're kind of left bamboozled about trying to understand what the right calculations that an employer must make. And unfortunately, it is fraught, but we do know those regulators, and we're here in Melbourne at the moment, but we know the Wage Inspector of Victoria is taking a great deal of attention to compliance with long service leave legislation. So I think we're going to find a much greater emphasis from them, and employers have kind of got the opportunity to catch up very quickly and get on top of that subject.
Yeah, incredibly difficult issue. Now that, I think, thanks Tony, that takes us to number 2 on our list, which is psychosocial health. And we've seen over the past few years, Katie, this has been an issue which WHS regulators have turned their mind to. It's no longer just physical injuries that they're looking at. And we've seen a huge overlap between our 2 areas, so the employment and safety, as the risks that arise in personal grievances, in misconduct issues, are now being recognised as safety issues. So what are you expecting to see in 2025 in this space?
Yeah, that's right, Lucy. More of the same, I think, and increasingly so. As you mentioned, safety regulators around the country now have dedicated mental health teams. They've specialised inspectors who are specifically focusing on investigating psychosocial risks in workplaces. In Victoria last year, we saw 5 employers criminally prosecuted for failing to, appropriately control psychosocial hazards involving matters like bullying, harassment, occupational violence, and that is coming from the state, the only state not to actually implement the psychosocial risk reforms. and Victoria certainly seems to be the most prolific in regulatory engagement in this space. 2024, the end of 2024, WA saw its first prosecution under the psychosocial health reforms under the Model WHS Act, and that involved a prosecution against the Department of Justice in WA for failing to have adequate processes, not none at all, but not adequate, to deal with inappropriate workplace behaviour, and that led to the psychological injury of a prison officer. So we're seeing issues of workplace management, of resourcing, of workplace processes, for redundancies, for complaint investigations, being squarely treated as work health and safety issues.
And Katie, these are quasi-criminal matters as well, aren't they?
Not even quasi. Yeah, they are. Yeah, they're if found guilty in a conviction, either an individual or a business will have a criminal record.
So this, and of course this operates independently of the kind of the established regime in the Fair Work Act, where there's an anti-bullying jurisdiction,
Absolutely.
which is a non-compensatory jurisdiction. Obviously, it's designed
like the anti-sexual harassment, the new jurisdiction as well.
Oh, spoiler, we're coming to that later.
Yeah.
But it's true. I mean, there's these multi-layered areas, aren't there?
Yes.
But what has been interesting for Lucy and myself as traditional employment practitioners is how we're watching the safety jurisdiction really take over a lot of this area, right?
Yeah, and certainly clients are having to deal with a number of investigators and regulators that might come from, the Fair Work Commission, from the safety regulators. And it's not just the complaints area. We've seen actually another increasingly overlapping issue with AI, and so another hot topic that we expect safety regulators to be focusing on this year. In particular, AI systems used in the workplace have been identified as potentially high risk for psychosocial hazards such as extreme micromanagement. And then separately, the increasing accessibility of AI technologies and developing computer editing tools, seeing workplace technology facilitating the creation of sexualised deepfakes and
I get the
feeling misrepresentation of individuals.
So I get the feeling that won't be the first or last time that we talk about AI on this series over the course of 2025. Yeah. So we'll come back to one of the issues, interestingly, that arises here in discussion of psychosocial health is actually the increase in investigations, maybe the increased expectation that employers have, and conversely the fact that employers themselves are becoming much more transparent with their expectations, and employees and unions and others are holding them more accountable. So we're seeing, presumably that's an explanation as well for the expansion of this jurisdiction. Yeah. We might come onto a sideline of that in a minute, but I wanted to move on to you again, Lucy. And we talked at the very beginning about this DEI thing, or the D&I. It does kind of annoy me a lot, to be honest, where we're talking about this term DEI in this kind of pejorative way that has never had any resonance here in Australia at all. And now our clients are immediately dealing and grappling with this issue, which has really arisen for our best friend Donald Trump in the US. So tell us a little bit about where this has arisen and where do you think it's going? Yeah,
it's such an interesting issue. So where this has arisen, as you will our listeners will have seen in the media, upon being inaugurated, Trump signed a number of executive orders, and the relevant ones here were executive orders around the rollback of DEI policies for those who want to contract with federal contractors. So the impact that's had is in the US and globally, we've seen organisations totally withdrawing their DE&I policies for compliance with that regime, in order to get that work from the US. But I don't think the impact will be limited just to those seeking that work. And we've already seen here Accenture withdraw their DEI policy here in Australia. So it's a huge issue, and I think it'd be naive to say it won't have an impact here, but there are differences here with DEI programs and the legislative framework, which mean I don't think it will translate across in exactly the same way.
Well, I think one of the other points that gets lost, because we're now talking about this global concept of DEI as if it's the same right throughout the world. And I know from our own clients, in fact, even our own firm's approach to diversity and inclusion, it's very much directed towards creating awareness and opportunities. It's never been about non-merit-based appointments or promotions for that matter. But there has in the US at least been a pushback against so-called affirmative action programs, and there was US Supreme Court decisions a year or so ago which actually held unlawful particular affirmative action race-based programs, which again created this kind of anti-woke hysteria perhaps in the US.
Yeah, it's a really polarising debate over in the US, but it is a different concept. They have the harder quotas there, and the affirmative action is actually unlawful in the US in some states. So they've had class action proceedings in the unlawful discrimination space. Whereas to contrast to here, most Australian jurisdictions have a specific exception in discrimination laws for special measures to address existing inequalities. We also have...
And you can do that without actually making applications through the relevant tribunal.
Exactly,
right?
different to the formal exemption process. We've also got a mandatory reporting requirements with the Workplace Gender Equality Agency. So there are barriers in place which mean I think it won't translate over in the same way. The last one actually being our positive duty here. So the interaction between the positive duty and a withdrawal of DEI or D&I policies is an interesting thing to watch and doesn't fit neatly.
So there's been, the question is, what are our clients doing about this, and how are they going to respond to the pressure, especially if they're a US corporation or got operations in the US, that there's often some expectation that doesn't matter DEI, same thing, you're subject to our rollback. Yeah. And I'm reading a bit about some, maybe whether they're savvy or not, let's call them savvy employers in the US who are taking steps to maintain the rage, if you like, to keep up the important work that their D&I programs are doing, but nevertheless somewhat dismantling the structure that they've got and incorporating the operations more broadly within the line of the business, and making accountability for diversity and inclusion and awareness and the like throughout the whole business. And Katie, in the same way that in many years ago, safety was a safety team issue, that's where it resided. And what have you seen over the last decade as our clients addressing that issue?
Yeah, well, clients who are doing it well, like you said, it's not just different, it's an issue for them, the safety team can deal with it, but it's being managed at, within the people team, within the safety team, it's being reported to, the relevant teams, certain learnings reported appropriately up to, the ERT, the board, and it's being shared, and genuinely it being a focus of the business rather than an allocated.
Yeah, and I think kind of that, as I said, that kind of this savvy employer is at least kind of reading the tea leaves, saying, okay, we don't want to destroy the brand, but we still need to maintain the progress that we're doing, because in the end, our clients and good employers are all battling for talent. They all want the best people. And we know, goodness, in our business where we're recruiting so many young graduates and young lawyers every year, they want to work in a place which is certainly not regressive and which recognises talent and rewards people, but also understands that, sometimes people from different socioeconomic groups or their LGBTI groups and so on have got a place, and people are respected for their individual differences, which I think is what probably D&I really means for Australian employers.
That's right. Yeah. So
Anyway.
it is a different
like for
concept.
like.
Yeah. Different concept. What's missing from the debate that I see playing out in the media at the moment is that nuance.
And when employers get it wrong, leading on to our fourth area of the top five this year, is we're already seeing, and we are going to continue to see, I think, a lot more of these personal grievances, whistleblower complaints, and as a consequence, employers conducting workplace investigations, either internally with their own resources or very frequently, as we often get involved with, where they're externally engaging specialists to assist them doing either complaint-based investigations or more broadly what we frequently call like culture reviews.
Yeah.
And we know from the last few years that there's just been a phenomenal increase in the number of these investigations over the course of the last few years. And I know you've been...
And then the subsequent complaints as well. If you read the AHRC's annual report, they lamented the massive backlog of complaints that they have to deal with, which they've seen since the COVID pandemic. And I think what's going to drive that further is these amendments to the cost protections under the Human Rights Commission Act, which came into force late last year, which make it a much more cost-friendly prospect for claimants to agitate discrimination claims.
And I've seen a bit of reading about that, certainly from plaintiff law firms who are really emphasising this point, because it's understandably been prohibitive for a victim of, can I use the term victim or...
complainant, victim,
complainant, whatever, of sexual harassment, for instance, who just is unable to afford the phenomenal costs of litigation.
And with the potential cost order being made against them, so they'll now have some protection against that. Just one more point on this. We're seeing at the first class action proceedings under the Sex Discrimination Act play out at the moment, and those cost protections will apply to those proceedings as well. So I think that's certainly an issue to watch.
So we're getting to time, and I wanted to just finish off on an area without wanting to tread on Rowan Doyle's toes here, because I know our Inside IR podcast will be looking at this in more detail as the year goes through. But one thing, we would be remiss not to mention one of the key issues that employers are confronting this year are the implications from the changes to the reforms from the Labor government over the course of its first term in relation to same job, same pay.
Yes, that's right. So
intractable bargaining.
Yes.
And multi-employer bargaining. I think they're going to be the three big issues in the IR sphere that are going to affect our employers. And interestingly, employers who may not necessarily have been regulated by enterprise agreements, in the case of multi-employer bargaining, may have avoided successfully or otherwise bargaining for many years. And also the case with same job, same pay, implications coming through. So
that's right, yeah. So same job, same pay, we've seen some action on that already. Our firm's acting in the current BHP same job, same pay test case, where we'll get some key answers around how those laws will operate. Who is a labour provider, how will the provision of service exception arise, and what factors will the Commission take into account in the fair and reasonable assessment. So once that decision comes out, the approach to resisting those orders will undoubtedly pivot.
And just on that, I just from one matter I did with one of my clients last year, it was very typical that there was an application made, and it's in the mainstream it's very difficult to reject a same job, same pay or regulated labour hire arrangement order, as it's known. It's hard to resist that if the relevant criteria within the legislation are met, and frequently they are. So, employers, by far and away, the majority of these applications have been granted and by consent so far. Now, we'll wait and see what the BHP case delivers, because at least it will give some greater guidance about how these terms might be applied.
Yeah, that's right. And what about intractable bargaining, Tony? I think this has been to date the most impactful reform in terms of how positioning and strategy within the bargaining room. What do you see for 2025?
This is also going to be, look, you know what, it's not the worst reform necessarily that the government could have introduced. There are real potential areas of benefits because ultimately no employer wants to die death by 1,000 cuts over a significant period. And there's kind of a 9-month period after which bargaining commences, which enables the parties to take advantage of bargaining. We know that the applications aren't granted as a matter of course, that the Commission will apply a real test to determine whether bargaining is genuinely intractable. But it does provide a mechanism for the parties to give up and say, okay, we want to bargain, we want to reach an agreement, but we simply can't. There are some complexities, and we know through to some reforms to those provisions that the Commission can effectively only arbitrate positively for employers, and therefore, what do I see playing out clearly in one sense? How employers are approaching strategically and tactically their bargaining processes to know what you concede and don't concede and when, and all of those things require prior planning, which really ultimately means that it's a good lesson for all employers to pre-prepare, to do perhaps more work than you've ever done in the past about how you're going to manage your bargaining process.
That's right. I'm sure Rowan Doyle will have more to say on that one. But I guess finally, multi-employer bargaining. We've seen a few developments. Last year we had the full bench of the Commission order the coal miners in New South Wales to engage in multi-employer discussions for a multi-employer enterprise agreement. The rubber, I think, will hit the road. I think this will be an area of focus for unions this year.
Look, I've got to be careful I don't say something too controversial on this subject because I just don't like the concept of multi-employer bargaining. It is now statutorily entrenched, but the concept of the Fair Work Commission arbitrating an outcome for bargaining is inherently inconsistent with the concept of bargaining. And
enterprise bargaining.
Enterprise bargaining, and then to have a common, we already have awards which apply if you like, the minimum standards, and then for the Commission to arbitrate and rope in potentially a whole range of employers who initially weren't even part of the arbitration process, kind of sounds extremely anti-competitive. And I know there's going to be a lot of criticism of it, and who knows, that might end up be one of the few issues I actually expect that will come into play in the forthcoming election campaign.
Yes, so that's right. So looking to the federal election this year.
What a segue.
What a segue. Not even planned. So early signs suggest that the federal opposition's reform agenda will not be expansive of the Labor government's first-term reforms. I think there's no surprise in that. Although we have seen the Liberal Party indicate a review of same job, same pay reforms, that they plan to reintroduce the ABCC and simplify the definition of casual employees. I've also seen some commentary around re-looking at the right to disconnect. So,
Look, it's a bit, the election's not far away, but I do think this is going to want to be a neutral issue for probably both parties, to be honest. We don't therefore expect a high visibility of IR or employment issues. Labor's done some very significant reforms in its first term. I think, as you've said, the Liberal coalition is going to want to pare back some things, but in the end, the way things look politically, it's going to be hard to get things through a fairly close, who knows, even the House potentially divided, but even the Senate will be a complex area to navigate for the parties. But it will be an interesting area ahead as we come, we're already well into the year 2025. I can't wait to get the opportunity to keep discussing these issues with you, Lucy, Katie, and of course with our clients again during the course of 2025. So thanks for joining us this week. Please, if you aren't already, become a subscriber to us at your normal platform. You can find us on LinkedIn or on email at insideemployment@hsf.com. Thanks for joining us.
Thanks for joining us, and we look forward to the next episode.